A massive shift is happening right now in the United States. And if you are an immigrant, a green card holder, a visa holder, or even someone planning to move to America in the future, this is not news you can afford to ignore. What Congress has just announced is being described by many experts as one of the most significant immigration reforms in decades. This is not just another policy update or a minor adjustment to paperwork. This is a fundamental change in how the United States defines, treats, and regulates non citizens living within its borders. The consequences of this new law could impact millions of lives, reshape immigration enforcement, and redefine what it truly means to hold legal status in America. Right now, there is shock, confusion, and fear spreading across immigrant communities nationwide. Many people believe that once they received a green card, their future in the United States was secure. They believed they had crossed the hardest hurdle, and that permanent residency meant stability, safety, and long term protection. That belief is now being challenged in a way few ever imagined. Congress has introduced a reform that does not just affect undocumented immigrants, but directly targets lawful permanent residents, students, workers, and visa holders as well. This development comes at a politically charged moment. With President Donald Trump back in the White House since January 20th, immigration has once again moved to the center of national debate. His administration has made it clear that enforcing immigration law aggressively is a top priority. What has stunned many observers, however, is not just the policy itself, but the fact that this reform was pushed forward with bipartisan support. Republicans and Democrats, historically divided on immigration, have come together in a rare show of unity to pass legislation that dramatically tightens the rules for non citizens. At the heart of this new law is a sweeping redefinition of legal status in the United States. Under the reform, the government is placing renewed emphasis on citizenship as the only status that provides full protection under the law. Everyone else, regardless of how long they have lived in the country or how deeply rooted they are in their communities, is now grouped under a single legal category, non citizen. This includes green card holders, international students, temporary workers, asylum applicants, and visa holders of all types. This change may sound like a technical reclassification, but its impact is anything but minor. For decades, U.S. immigration law recognized clear distinctions between different types of non citizens. A lawful permanent resident was treated very differently from a temporary visitor or an undocumented individual. Those distinctions came with legal protections, due process, and discretion by immigration judges. Under this reform, many of those protections are being weakened or removed altogether. Green card holders, once considered permanent members of American society, are now subject to stricter scrutiny and harsher enforcement standards. The law effectively places them on the same enforcement footing as other non citizens, meaning their status can be challenged, revoked, or terminated far more easily than before. This shift has sent a chilling message to immigrant families who believed they had finally achieved stability after years of struggle and sacrifice. One of the most controversial and impactful elements of this reform is its dramatic expansion of deportation grounds. In the past, deportation of a lawful permanent resident typically required serious criminal conduct, such as aggravated felonies or repeated offenses. Immigration judges often had discretion to consider factors such as family ties, length of residence, employment history, and contributions to the community. That discretion is now being sharply limited. Under the new law, certain offenses that were previously considered minor or manageable now carry severe immigration consequences. A single conviction for driving under the influence, commonly known as a DUI, can now trigger deportation proceedings. In some cases, even an admission of having committed a DUI without a formal conviction may be enough to place a non citizen into removal proceedings. This is a radical departure from previous practice. DUI laws vary widely from state to state, and many states treat first time offenses as misdemeanors with limited penalties. Under the new federal immigration framework, those state level distinctions no longer matter. Immigration law now applies a uniform standard, meaning that any DUI related offense can be treated as grounds for inadmissibility and deportation, regardless of how the state classifies it. The implications of this are enormous. A green card holder who has lived in the United States for decades, raised children, paid taxes, and built a career could lose everything because of a single mistake. There are no second chances built into this system. Once the trigger is pulled, the process moves quickly and decisively toward removal. The law goes even further by establishing DUI-related conduct as a one-strike offense for immigration purposes. If a non-citizen is convicted of or even admits to certain DUI-related behavior, they can be deemed both inadmissible and deportable. In plain terms, this means they can be barred from entering the United States and forced to leave if they are already here. For many, this could result in permanent separation from their families and communities. Another deeply concerning aspect of the reform is how it treats admissions. During visa interviews, border inspections, or immigration applications, honesty has traditionally been encouraged. Under this new framework, however, an honest admission of past conduct could be used as evidence to initiate removal proceedings. Immigration attorneys are warning that this could create a climate of fear, discouraging non-citizens from cooperating with authorities or seeking legal remedies. Beyond deportation, the law also introduces stricter standards for what is known as good moral character. This concept plays a critical role in immigration benefits, especially naturalization. To become a U.S. citizen, an applicant must demonstrate good moral character over a specified period of time. Under the new rules, a DUI is no longer viewed as a lapse in judgment, but as a serious moral failing that can permanently disqualify someone from citizenship. This means that even if a non-citizen avoids deportation, their path to citizenship may be permanently blocked. Years of lawful residence, community involvement, and personal growth may no longer outweigh a single offense. For many immigrants who have dreamed of becoming U.S. citizens, this is a devastating blow. Lawmakers defending the reform argue that it is necessary to protect public safety and restore confidence in the immigration system. They point to the dangers of impaired driving and emphasize that citizenship carries responsibilities as well as rights. By imposing strict consequences on non-citizens, they claim the law sends a clear message of zero tolerance for risky behavior. Critics, however, argue that the law goes too far and undermines principles of fairness and proportionality. They warn that the removal of judicial discretion could lead to unjust outcomes and tear families apart. Advocacy groups are already preparing legal challenges, arguing that the law violates constitutional protections and long-standing legal precedent. What is undeniable is that this reform represents a turning point. It marks a shift toward a far more rigid and enforcement-focused immigration system. The message from Congress and the White House is unmistakable. Only U.S. citizens enjoy full legal security. Everyone else must navigate a system with little room for error. For immigrants living in the United States today, this law serves as a wake-up call. The margin for mistakes has narrowed dramatically. Actions that once carried manageable consequences can now threaten an entire future. Understanding the law, seeking legal advice, and exercising extreme caution have never been more important. As this policy begins to take effect, many questions remain. Will additional offenses be added to the list of deportable conduct? Will future reforms push the system even further in this direction? And how will courts respond to challenges against this sweeping change? Here at Legal Lens USA, we are committed to monitoring every development closely. Immigration law is evolving rapidly, and staying informed is the best defense against uncertainty. If this update has opened your eyes, make sure you stay connected, stay alert, and share this information with your community. Knowledge is power, especially in times like these. The future of immigration in America is being rewritten right now. What happens next will shape the lives of millions for years to come. Stay informed, stay cautious, and above all, stay prepared.